Today is William Schneider. As stated by this court in its announcement seeking amicus briefs, I think this is the way to identify the issue in this case, is that whether the rule enunciated in Gamache, preferred mutual versus Gamache, permitting an insured to recover attorney's fees in a successful coverage dispute with its insurer over a duty to defend should or should not extend to disputes concerning the insurer's duty to indemnify. And when I look at that issue in this case, I try to determine what exactly was the rationale in the duty to defend cases like Gamache, like Rubenstein, and Holden.
Have you found it?
I think I have, Your Honor. I would state that it seems to be a special relationship exists for that kind of obligation, that duty to defend.
In other words, they step beyond just indemnity and say, we're going to go one step further and defend you.
Yes. That is, and I believe this Court's holding in Golden, in particular, talked about the special relationship and the burdens of having to carry litigation costs, even before you've had a liability established against an insured. They have this immediate, heavy burden, financial burden. And in that sense, an insurance company almost becomes like their guardian through this process. Oh. And it's different from the other duty to defend.
Guardian?
If they defend, I suppose, is the question and the answer. But that's what they're expecting. That's what the promise.
When I drive my car, Arbella is my guardian? Does that distinction make any sense? That you're
yes, I think it absolutely makes.
True?
I think it makes an absolute sense because it truly becomes something that you don't get the benefit of if you have to litigate. You just don't get the benefit of defense if you have to turn around and hire attorneys anyway. That is such a unique aspect of an insurance policy that is different from the more standard indemnity provisions, which is just like any other contract. And this Court has held that absent any ambiguities, and we're not talking about ambiguities.
I suppose you could add to that equation that in defense cases, the insurance company has a way out because they can defend under a reservation of rights. But I suppose that doesn't affect it either because that only pertains to indemnity. So we can't rely on that.
Well, it's interesting because I know this Court has cited to the Hayseeds case from West Virginia, as I would like to consider it just dicta to support the special relationship and the duty to defend. And I know that case had gone farther in that minority state, West Virginia. There are only 3 states that have held that the duty to indemnify, if you prevail as an insured, that you would obtain the benefit of the attorney's fees and an award of that. There are only 3 states, and that's Minnesota, I believe it's Washington, and West Virginia. So it is
I thought Minnesota is the other side of that. Am I wrong? No, go on.
I believe it's Minnesota.
That's all right. I'll check.
Isn't it Montana?
It's the Olympic versus Sentinel case from Washington. I'm sorry, it's Montana. Sorry, Montana. And that's the
Minnesota's
Mountain West Farm.
side,
Thank you. Sorry, Minnesota, Montana. And so it's a minority position, and I looked at that case in particular to try to see how they try to distinguish why in the context of an indemnity, duty to indemnify, they award attorney's fees. And it just seemed very unconvincing to me. They talk about unequal bargaining power. Not to belittle that as an issue, but it's not convincing as a distinction because so many contracts have that same scenario where you may have unequal bargaining power between the contracting parties. And they also talk about reliance on the policy. Well, again, reliance, that's in every contract of some sort of promise in a contract. So I found that case very unconvincing for their way to distinguish. And if this Court is presented with trying to find a line and a reason and a rationale when you would create an exception to the American rule, it would be very difficult based on the Hayseeds case is what I would
I suppose
contend.
You could say, because an insurance policy is a contract, that if we said you have to pay in the kind of case we got here, then you might as well say in any contract case.
Absolutely. And why limit it to the insured? Why not have the insurer be able to
Well, the opposite of the American rule, at least in our jurisprudence, is the English rule, and
Yes.
that is the losing party pays, not only one party who loses pays.
Right, and I think some of the amicus briefs that came in on this case, especially I'm focusing on the Boston Gas and the Century Indemnity, I think that just proves the point that it's not always about unequal bargaining power in an insurance context. So, I mean, that's a case where you've got two heavy hitters going at heavy litigation, and it's not one side that's got the unequal bargaining power, at least in terms of the litigation and perhaps even in drafting the policies that they have.
The trouble is that, unfortunately, for better or worse, insurance companies have a bad image. And that's what's driving this, to some extent, driving this argument that they, ordinarily, and maybe it's right, maybe it's wrong, won't make payments. They'll rely on exceptions, exclusions, this, that, the other thing. So therefore, they ought to get hit with attorney's fees.
Well, I think that's a broad overgeneralization and most of the time wrong. And
well,
I'm
not saying it's right. I'm not saying it's right, and I'm not saying it could. Obviously, it can't be used as any sort of justification for extending the rule. That would be totally irrational.
Well, and I just don't see it any rationale at all to extend it in that case, unless you open it up to the whole slippery slope of all contracts. And why even stop at contract law?
You're saying that the rationale for limiting the prior cases, the change in the American rule, is because with the duty to defend, the insurer is a type of guardian. That's your argument.
Something along those lines where that's the expectation of a duty to defend, where it's an upfront, immediate desire when someone goes out and obtains an insurance policy, that is their primary concern. If they get sued, the payment of attorney's fees to defend them. And that's regardless of whether they're even going to be liable or found liable or have any other kind of exposure in that litigation. So it's a very unique kind of expectation. And I read the cases.
Mr. Jensen, it struck me, guardian and special relationships are not languages that I feel very comfortable with, but it struck me that one of the differences with the duty to defend is that, and I'm mentioning it now so that Mr. Walsh can think about how to rebut it, is that in the first-party insurance cases, in theory, and assuming that the insurer loses, the insured can be recompensed by an award of monetary damages. The house may, you may delay rebuilding your house. You may have gone into bankruptcy because the disability payments haven't come, whatever it is. But the duty to defend, in essence, you can't really pay by monetary damages simply because somebody has an attorney. Part of what I'm doing when I'm buying a duty to defend is I don't want to have the responsibility of ascertaining who a decent lawyer is. So I may have lost the case, for example, because I retain somebody whose expertise is criminal defense attorney because I happen to know that person.
And I would add to that there's the risk of an excess judgment as well in that context too. That if you don't get good representation, it may go beyond the indemnity provisions as well. And if that's ultimately litigated,
there may be other insurance contexts of which I can't think. I mean, where money alone would not put you in as good a position as before. Pollution, hazardous cleanups. Maybe you shouldn't have to. Have expended all that kind of money, but it seems to me that if a court looks at that and says, no, you had an obligation to come and do the cleanup or to cover the cleanup, money will essentially make you whole. The duty to defend, I think it's very hard to argue that money alone would make you whole.
Yes, and I think that you could, you mentioned bankruptcy, and I suppose you could just look at that and say there's a monetary aspect to it, but there's another aspect to if you become bankrupt, it's more than just the monetary aspect. So a lot of things could happen in litigation, I suppose, where that could be a big difference in your life. And I really do see that special relationship as cited in Golden. And there's also a very good Massachusetts District Court case by Judge Woodlock, and it's cited in my brief on that point. And it's the Liberty Mutual versus Black & Decker case, which really tries to sort of anticipate what this court would do in the case where you would separate out a duty to defend from a duty to indemnify. And it really talks about you can't make someone whole once you have to litigate this, because I suppose lots of things could happen. You could the time loss, perhaps, if your reallocation of resources to.
Well, you have that. I mean, I'm thinking of the case we had earlier today, and my bankruptcy was actually going to that. If you're not paid disability payments and your and your employer doesn't cover you, and you really have no income, that's a problem.
Yeah.
And may push you into bankruptcy, but
But I mean, in this case, it's a very simple contract dispute. We have, something which I don't think is a completely, I don't think it's a remarkable case in terms of the underlying issues here. It's a straight contractual indemnity case. And where there's a contract of indemnity where it's not, there's no implication of ambiguities in terms of a duty to defend in this case. I don't think anyone's arguing that. It was on cross motions for summary judgment. It's about a straight contractual right, and I just don't see how the line gets drawn on the basis of a case like Hayseeds, which would be piecemeal. You'd have to look, well, what's the unequal bargaining situation here and the reliance compared to other cases, and I think it's an unmanageable way to look at it. I don't know what other ways to look at it if one were really contemplating expanding it out to the duty to indemnify, because that application of unequal bargaining power is in all sorts of contexts, and so you might as well open it up to every single contract or all cases, and I just don't see where it stops. I just can't see where it stops on that. You have these cases where there's a special relationship which this court has recognized, and that's a very good, clear line with this litigation insurance, where you really are trying to protect someone up front on something they really rely on in a very distinct way than they would other contractual provisions. But if you just say reliance and, unequal bargaining power, it's just not particularly unique to insurance contracts, and I don't know why it would only arise in the context of an insurance contract. I don't know why it would be singled out in that setting.
I suppose if you, as was alluded to in the other case, if you superimpose 93A on it, then you could argue, well, there is a mechanism here, despite unequal bargaining power, whereby if insurance companies act improperly, bad faith, unfairly, blah, 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 violate 176D, you can get attorney's fees, and they can get socked for multiple damages and all kinds of other things.
Yeah,
so there is a protection there, and they are acting basically honestly. I mean, here the issue, although the judge found against you, is a legitimate issue to argue over, whether this guy had a hobby or a business. Legitimate issue.
And I think this court should be concerned about cases where decisions are made by insurance companies not to litigate if they're going to have the risk of this, and the policy premiums could go up if they just start paying off and saying, well, it's not worth the risk. This is a potentially a $50,000, $60,000 case. Attorney's fees could almost equal that. We won't do it. So all of a sudden, all these cases, there's also perhaps the motivation of people to file suits, maybe prematurely, while there's still an investigation going on, in order to say, you haven't made your decision in our favor yet. We're suing you for indemnification. And maybe the insurance company would ultimately agree, but now you'd be confronted with a case where they'd have to pay attorney's fees because...
Mr. Jensen, could you just address the reasoning of the judge in the Superior Court, not Judge Billings's ruling on the liability, but on the attorney's fees? Maybe you could...
I'm sorry, on which issue?
On the attorney's fees.
On the attorney's fees. Is there something in particular? I think he said the benefit of the bargain was his point. I saw that as the punchline. And again, that seemed to me more like a Hayseeds unconvincing kind of analysis, because he did seem to recognize that this court has really only done it, abrogated the American rule in the context of the duty to defend, but then he just says, well, to get the benefit of the bargain is I think one of his...
I think what he was doing, which is what trial judges try to do, is follow what the Supreme Court says, the Supreme Judicial Court says. I mean, he quoted the policy behind the rule that we set out in Rubenstein was the promise to defend the insured as well as the promise to indemnify. Is that just sloppy language in the SJC's decision?
I would never say that.
I'm sure the trial judge didn't say that either.
I would think that perhaps it did sneak into the language, because a lot of these cases are tried together with the duty to defend and the duty to indemnify. But as I read all the way through Sullivan, the Sullivan case even, there is one exception. I believe it's the Sullivan versus, I think it's Utica Mutual case, which more recently even said there's one exception, and it's the duty to defend. So to the extent that there may be some discussion of cases where there are both duties are being litigated, This court is always focusing on the duty to defend.
Would you agree with me, when you talk about benefit of the bargain, that Mr. Wilkinson has not been made whole? His damages are $38,000, and he's got to pay his lawyer. So whatever that is, we'll say $10,000, he gets, for what should have been $38,000, he gets $28,000.
But if this court is thinking about trying to move the line or create another exception or expand the exception, I don't know how you can draw that line, because there are many contracts where that could be the case. There could be many.
I understand that, but what I am concerned about is that trial judges try to follow our guidance, and it seemed to me that the trial judge in this case was reading Rubenstein very carefully and trying to figure out what we were talking about. And it's all very well to say, well, it arose in the context that they often tried together. They're actually not often tried together. They may or may not be. But there was language about what the benefit of the bargain was, and he very carefully goes through Rubenstein. And what I'm saying to you is, if we go with you, do we have to essentially rewrite Rubenstein?
I mean, I read Rubenstein as still focusing in on the duty to defend. I think there is some language in there which encompasses
coverage rather than duty to defend.
I think there is some language there. I think it comes through because the cases have always dealt with, or often have dealt with, the two duties being litigated at the same time, and I think that maybe does need to be clarified. I think the citation to hayseeds, from my position, I see the use of it, but if people go back and read that case, they're getting a very different holding than this court has given.
Okay.
A completely different holding.
Thank you, Mr. Jensen.
Thank you very much.
Mr. Walsh?
May it please the Court, my name is James Walsh. I represent the plaintiffs, the Wilkinson in this case. It was very interesting this morning that the central question in this case was posed by Justice Cowan when she asked one of the lawyers, what is the difference between an insurer's duty to defend as opposed to a duty to indemnify? And I felt that the answer to that question is clearly that there is no difference. In my brief, I've clearly relied on the Rubenstein case principally, and even more than that, the fact that in Rubenstein, this court relied heavily on the hayseeds opinion, which, after all, really was very similar on its facts. It was a fire in which the plaintiff's restaurant was burned. The plaintiffs lost their property. The insurer rejected their claim and even went so far as to accuse them of arson.
But how do you segregate insurance contracts out of the mix of, as your brother has pointed out, out of the mix of all other forms of contracts? I mean, the people then are, if we give you what you want, people are then going to come in and say, well, I got a contract here to buy a refrigerator, buy a car, buy a house, buy whatever, so I get my attorney's fees.
Right. Well, of course, insurance contracts, the courts have recognized, are somewhat unique to the extent that the insurer is the one that chooses all the language. They choose all the conditions.
Well, subject to the commissioner.
Correct. The definitions of various conditions and precedents are all put in there by the insurer.
So those contracts are construed against the insurer in many respects for that very reason.
Yes, and I think that's the reason. You'll notice in my brief, I haven't made an argument that the plaintiffs in this case had an unequal bargaining power with the defendant. My point is this. As the court said in Hayseed, which is clearly dicta, they said when an insured purchases a contract of insurance, he buys insurance, not a lot of vexatious, time-consuming, expensive litigation with his insurer. And I think that is really the basis for this court's ruling in Rubenstein, because the insured has had to spend money to prove that the insurer made a bad call. They called it wrong, and who should pay for that mistake? The insurer or the insured? And I think it comes down to that, especially in a case like this, where the amount of the original fire loss in this day and age wasn't that much. It was $38,000. But the plaintiffs, to this point, have had to spend almost that much to prove that the insurer was wrong when they denied the coverage. And if the American rule is to be applied in this instance, what did the insureds win? What did the Wilkinsons win? They won nothing.
It seems to me that the issue really arises not so much when there's the benefit of the bargain I mean, not so much with the unequal bargaining power, but when your claim is relatively small but significant to most individuals. $3,800 is a significant amount of money to most, Massachusetts homes, families. But there's no way that you can litigate all the way to the Supreme Judicial Court for $3,800.
Right. Well, because this was $38,000. Actually, that figure was agreed to at the trial court level. There was actually more than that. But before I forget it, I would like to remind the court something that you probably already know of. But since our briefs were filed in this case, the appeals court in October came down with a case called Safety Insurance versus Day at 65 Massap Court, page 15. And although that case involved a duty to defend, the language in that case, I think, is significant because the case, let me quote from it, the prevailing insured is entitled under her contract to both to a defense and to indemnification. If she must incur legal fees and related expenses to obtain either, the value of her contract is diminished. I made the appeals court aware of that case under Rule 16 just before the case was transferred here. And it's interesting that in reading the amicus briefs, Judge Zobel in the federal court used this safety case as a basis to award attorney's fees. So,
What did Judge Woodlock say in the Liberty case?
as I understand it, Judge Woodlock applied the American rule in that case.
Suggesting that that's the rule that this court would apply, separating out these two different
Yes,
duties.
because I don't respectfully agree with that. I think this
And
court,
on what basis did he separate them out?
Your Honor, I read the opinion, but frankly, I didn't analyze it to great extent since it was only a district court opinion and not an appellate opinion. But I've always felt that the logical thinking that's presented at Rubenstein would clearly say, look, this is a case where the American rule would be inequitable if it were to be applied to the Wilkinsons.
Mr. Walsh, would you, I suppose you would agree with it, but it seems to me that the attorney's fees judge in this case tried very hard to follow Rubenstein, correct? I mean, that's what...
Yes, I think so, Your Honor.
So does that mean we need to amend the language in Rubenstein if we are to rule in favor of citation?
I think that there'd have to be some sort of distinction drawn, and I suggest it would be awfully hard to do that. Clearly, the answer would be yes. You would have to somehow...
Well, I suggested one, which was that the duty to defend cases, and I think it was one of the bases of Judge Woodlock's rulings, was that an award of monetary damages post hoc would not put the insured into, it would not make the insured whole. Now, your claim here is if the insured has to expend legal fees, then the insured is never made whole in any event.
Yes.
But you are really not made whole when, in other words, ultimately your clients will get the $38,000, correct?
But they've spent almost that much to get to that point, and that, I suggest, is really not what they bargained for when they bought this insurance policy. And this is one of those instances where, as the court said in Hayes, the American rule works badly in this sort of context. It works well in many, many other instances, but it just doesn't work in this situation. And that's really all I have to say.
Thank you, Mr. Walsh.
Thank you very much.